also rather validate the same aspect. However, estimated 1/3 of world population still lacks regular access even to products which are included in WHO model list as essential medicines. In such a scenario, it became an important how to rather provide provision that even essential medicines which are not available to large masses, it becomes available, which is a basic need. So if we look at it, what are the criteria? It is very well known, public welfare certainly, non-working of an invention, block improvement invention for dependent patent, and likewise. As a professor has already elaborated on how it came into being, for that reason, WTO member states in Paris Convention rather came to a conclusion, common consensus, that it is essential that all the WTO member states protect patent rights in their respective states. Then only there will be very good interaction, well-knitting and trade in the interest of all the member states. For that reason, there are many deliberations, and eventually they came into conclusion that we have to have an agreement among all the member states for this, and there has to be guidelines based on which certain legislations have to be enacted, providing provision for protection of proprietary rights in all the member states, at the same time not to misuse those rights, which might be against the public interest of each member states. For that reason, they came out with the TRIPS agreement, which provides a guidelines to all the member states. And in those guidelines, as regards patent, Article 27 says all member states have to ensure that intellectual property rights of all the member states has to be protected in all the states. And then it came into notice as this WHO and all the member states agree to the extent that even essential medicines are not available to the common masses. And in developing countries like in India and all underdeveloped countries, there is a prime need that patent rights are not misused, which deprive the needy people of the basic medicines and even for other diseases like cancer, etc. However, all the patent owners and innovator companies, they said if at all you dilute the patent rights for this aspect, it will be forfeiture of their patent rights. And they say non-voluntary license to domestic products without authorization of the right holder under national emergency or extreme urgency, so long as due process requirements are met. They said, yes, if at all such a need arises, then patent holder must be contacted, must be pursued to issue a voluntary license. In case it doesn't happen, he rather misuses his rights, and as a result of it, there is a national emergency, there is an epidemic. Then they provided a clause 31 that it has to be only for national use, only for the domestic use, not for commercial use at large, that it can be rather made as such and exported and likewise. Then it says, in 2001, Doha Ministerial Conference decided that this should be changed so that countries unable to manufacture the pharmaceutical could obtain cheaper copies from elsewhere else. When they say it is for only domestic use, this was under paragraph F of that Article 31. They said there are many countries who do not have expertise, who do not have scientific expertise to make some medicines. So they will certainly be, if you limited that it has to be made only for domestic use, not for exporting, then all those countries will be deprived of such medicines. Then they say in 2003 that some change should be brought about to ensure that it becomes available to even population living in underdeveloped countries who cannot make on their own. They do not have neither infrastructure nor technical expertise. Then in November 2000, Doha Declaration on TRIPS Agreement and Public Health was adopted by the WTO Ministerial Conference, and it reaffirmed flexibility of TRIPS member states in circumventing patent rights for better access to essential medicines. Then paragraph 4, then Doha Declaration, there's a paragraph 4, lot many deliberations are there. And one of the things under paragraph 5 was to ensure that population, people from the underdeveloping countries they also have access to some medicine. They were said the paragraph F should be deleted. Therefore, countries, some places who have a capacity, who have expertise, who have infrastructure to make it, they must have rights to export to such locations where they neither have an infrastructure nor technical expertise, so that they too have an access to that. It was decided, and paragraph F of Article 31 was rather temporarily removed, which in turn later in 2005 was made permanent, and it was allowed to all the member states for making medicine for export to underdeveloping countries. Then there was certainly much uproar among innovator companies that this is certainly forfeiture of their patent rights. Then Paris Convention was held, wherein it was discussed in elaborate manner under various paragraphs. And paragraph 1 said that import of drug at a place where they neither have a expertise nor infrastructure in no way amounts to this forfeiture of the patent rights. To ensure there is no misuse of such a provision in TRIPS agreement, many countries, to the extent of 33 countries, I think, they decided they will not at all make use of this provision TRIPS agreement. They will neither make such drugs for which there is a provision for compulsory licensing for their domestic use, nor they will import into their jurisdiction made at other places, so that there is no misuse of such a provision. There is no misuse of such a provision. So accordingly, this came into being, and all the member states have to enact legislations accordingly. As already demonstrated in a very elaborate manner, Mr. Singh, how it came into being, and they said, in India in particularly, I will not touch upon that much, if at all, one of the provision most of the countries adopt, if at all any patent which has been granted, and 3 years therefrom, after the grant, if it is not being practiced, there is a provision for compulsory licensing. This is one of the aspects. And secondly is certainly affordable price. It has to be at affordable price. And thirdly, and one aspect is availability. It must be available in sufficient quantity so that it is available to every needy person. Together in a combined manner, all these aspects, a decision is taken whether compulsory licensing should be granted or not. In India, in addition to non-compliance of Section 83, that's not being worked, and then under 84, one can approach for the grant of compulsory licensing. There is another provision under Section 92, wherein government itself, looking at there is an epidemic and there is a need for such thing, they on their own can keep some patents responsible for some drugs which are cause of this scenario, and they can rather take action and rather put them under compulsory licensing under Section 92, for which generic companies don't have to apply on their own. Rather, they only have to approach the Controller General office, asking them that they're going to do it, and they should be granted formal permission. These are the provisions in India. Similarly, as you know, US has certainly been against this compulsory licensing provision. As Mr. Singh has said, there has been many compulsory licenses in US before it came into India. But this was under Sherman antitrust law. One of the beautiful cases is certainly Eastman Kodak. That is not under US Code 35, which covers primarily patent, all the sections related to Patent Act. This is under US 28, wherein any patent which is barring competition and patent owner is not ready to give voluntary license, that for that company which is being impacted adversely can approach for compulsory licensing. And there has been a beautiful case of Eastman Kodak, wherein they had a patent for a product for a Xerox machine, and they were neither using it nor supplying the product out of that to their competitor. And the case went up to Supreme Court, wherein against 5% royalty, compulsory licenses are granted. However, under TRIPS agreement, US also had to enact legislation under USC 35. There was much deliberation. However, in 2005, it came into being, and a section 158 has been rather only for compulsory licensing, but for that rights are only to the health secretary, and that too for making products for export, not for domestic use. I think after having shared the basics of TRIPS agreement, etc., it will be more appropriate and more productive if at all we rather have a discussion with such an august audience and get more clarity on different aspects of compulsory licensing. Thank you for the patient hearing.